Defendant Trump there passing on an opportunity to engage the press corps that's assembled for him, but maybe he wasn't as interested in the question about what was confirmed today. He will not be testifying in his defense at this trial, as is his right. We are now, as promised, joined by Andrew Weissmann, former FBI general counsel and a senior prosecutor in the Mueller probe. Welcome, Andrew.
Nice to be here.
Jury instructions are boring but important. Agree?
Totally
And
agree.
we don't have it all set yet. I like to be very clear with people. We don't have them all. When we get them, we'll be reading them, and we can kind of announce whether they seem really standard or slanted any which way. Let's start, though, with the wrangling over instructing on the campaign crime and the money. Tell me about that and what you thought you heard.
Well, there was one part that I thought was really interesting and good for the government, and it's that the state, in order to make this a felony, has 3 separate crimes that they're going to point to say if you committed this false business records, but with the intent, just the intent to aid or conceal another crime, you've got this felony. And they pointed to 3 separate crimes, 1 federal, 2 state. And one of the arguments was, does the jury have to be unanimous about which of the 3? In other words, if you have 6 saying it's this one and 3 saying it's that one and 3 saying it's that one, is that sufficient? Or do they all have to be 12 saying it's this one? And the judge says, as long as it's unanimous that that they all agree that at least 1, but they don't have to agree on the same one, that it's sufficient.
Which is bad for Trump.
Bad for Trump.
Can I make a crack comparison?
Yes.
So if you're doing a crack prosecution, but there's a possibility that the powder was illegal fentanyl, street fentanyl, instead of crack. As long as you can get the jury on board that this was illegal substance, contraband, right, you're good. And that's sort of the analogy here. If you're going at a drug charge, right, you don't get to say, oh, no, you guys are split. Different crime. Yes, I clearly have 12 people who think I committed the crime, but they're split on it if they are bundled together like this.
Yeah, I mean, that's an analogy. It's basically I guess you said we're going to be in the weeds.
Let's go.
Gardner.
Yeah.
The legal term is that it's methods and means. In other words, the methods and means by which you carry out a crime is not something that the jury has to be unanimous about. They have to be unanimous about what's called the elements of a crime. Every crime has certain elements. That there has to be unanimity. But this is a good ruling because there's a sort of a smorgasbord of choices, and you do not have to have unanimity. That, I think, was really useful.
And that reminds, I think, people who've been following the trial that there was so much emphasis on what Trump's intent was in covering it up, right?
Exactly.
And so, again, if you want to be as fair as possible, and there's a defense that he had these other legal reasons to cover it up, in court of public opinion, people may judge it, voters may judge it, the Christian right group of political Republicans used to judge that, but that's separate. Here, the only thing is, to your point, can they demonstrate, and the jury instructions demand, that he's doing this to cover up some other crime, and if you're saying disagree on which crime, that's okay.
Yeah, and the other, to your point, this came up, and then the judge dealt with this issue in the jury charge. What if the state proved that 50% of what Donald Trump was thinking was campaign violation, and 50% was Melania, personal.
Real existential type division. Okay.
Or if it was 90-10, or you make up your own hypotheticals in math. What does the law require? Does it have to be 100% campaign or tax? Or what if there's some portion that he was thinking about just protecting his family? And the law in New York, and the judge basically said this, is that it does not require the state to prove that it's 100% campaign.
Right, which would be odd.
Exactly. And so the judge said, no, there has to be, you can have dual motives. The state doesn't have to prove that the only reason that you were doing this. Now, obviously...
Well, let me jump in. I mean, someone could have a big public-facing job. They're the CEO of a big company, and there's evidence that they beat up on their wives, let's say. Their motivation might be to avoid embarrassment and also avoid the fact that they allegedly committed a crime of battery, right? The fact that they're also worried about losing their job, which is not legal, or being embarrassed or being kicked out of their country club, that doesn't extinguish and vitiate
Right.
the illegal intent, no?
Exactly. And so we'll know exactly what language the judge is going to use on Thursday. One of the things that Judge Merchan, who's just been spectacular, is doing is he's going to make sure on Thursday that the public and also all of the parties see exactly what he's going to charge the jury.
Right.
Why is that important? Because as you and I know, when you're then preparing your summation, you want to know, well, what's the judge going to say the law is so that you can address that in terms of telling the jury, this is why we have established the facts, or on the defense side, this is why they haven't established it. But you need to know what you're sort of shooting against. And so the judge is going to give that to them with plenty of time to be able to prepare.
Yeah, and that'll be what? I'm going to keep you over the next break, but briefly, that's just a couple pages what we ultimately get.
Oh, it should be long.
How long do you think it'll be?
It could be like 30 pages of jury instructions. Yeah.
Wow.
It's long.
That's longer than I was thinking.
Yeah, they're long.
Because of the theory of this case, or in general?
In general, jury instructions are long, and and then the judge sometimes will actually give the actual charge, print it out and give it
and
to
do the
jury.
checklist. Yeah.
Less than 2 weeks before the presidential election, Michael Cohen wired $130,000 to Stormy Daniels' lawyer. That payment was to hide damaging information from the voting public. The scheme violated New York election law.
That's the case, as described by D.A. Bragg. We are back with Andrew Weissmann. We turned finally to 2 days of defense, and they had a rough 2 days. Here's one moment people have seen from what I called the hot mess of this Giuliani ally Costello. The judge says, listen to the question, answer the question. We're dealing with a lawyer and former prosecutor. It's worse when you break the rules and you know them so well. He says, well, can I say something, please? And that is kind of how he talked, so I'm being fair. That's a decent reenactment, Andrew. And the judge says, no, this is not a conversation. He knew better. He still acted this way. Was it a hot mess? Did he hurt the defense effort?
And that, by the way, that quote is maybe the least of it. He said
Yeah.
he said twice to him, the judge to the witness, outside the presence of the jury, your conduct is contemptuous.
Yeah.
He was a huge mistake. It is better to not put on a witness if you're the defense than to put on a bad witness. The jurors are going to be like, you had a defense and this was your defense. Here's what I think the state is going to argue in summation. They're going to be saying, you saw an obstruction scheme. You saw it in black and white that was orchestrated by that man, and they will point to Donald Trump, and it was carried out by Bob Costello and Rudy Giuliani. And what was the goal? To have Michael Cohen never take the stand. You do not do that if you are innocent. You do not do that if you are not worried about Michael Cohen. And so they will use it to show consciousness of guilt. They will use it to show that Donald Trump is a ringleader and the head of this group. And they will use it to sort of rehabilitate Michael Cohen to say they knew exactly that he had the goods.
I got 30 seconds left with you. Is that case stronger with the defense having put him on?
The state's
The
case?
DA's ability to bloody it. Yeah.
Absolutely.
Yeah.
This was a huge mistake. I know some of the defense lawyers cannot imagine that this was their choice, that they are too good to be thinking.
So bad it looks like malpractice, but maybe Trump forced them into it as a client, you're saying.
Well, the client can, it's not forced, the client
You know what
can
I mean?
make the
Demanded
client,
it.
Exactly. The same way that, listening to Donald Trump say, I wish I could have testified. Just to be clear, it's his choice.